Hello everyone and welcome to the Bird and Bird International L&E Club. In this podcast series, we will hear from our international team of employment law experts on a variety of cutting-edge topics. Each episode will provide 5 key takeaways on a key L&E theme with a US focus in 10 minutes. I'm Patty Walsh, a US-based partner within the L&E group here at Bird and Bird, and I co-head our San Francisco office. Hello everybody and welcome to our L&E Club podcast series, 5 key takeaways in 10 minutes. And today we're asking the question, how can US businesses navigate reorganizations and layoffs in Europe? Simple question, and the person I'm going to ask to answer it is Furat Ashraf from our UK team. Furat and I work together almost daily, and she focuses primarily on helping US businesses navigate their employment law challenges outside the US. Over to you, Furat.
Hi, Patty. Thank you for having me. It's great to be here. I mean, clearly this could not be more topical at the moment. I don't think a week has gone by in recent months where a business is not announcing layoffs. There are a multitude of reasons we've seen be communicated. Overhiring as a result of the pandemic boom, streamlining of resources, reorganization of product lines or functions, offshoring, and above all, simply cutting costs in anticipation of quite difficult times ahead. What's interesting is that in some cases, these are businesses that aren't really used to doing this. I mean, you'll obviously have the financial services industry that run these programs annually, but take tech as an example. There were obviously periods of downsizing at the height of the pandemic, but in truth, it's been nearly a decade now of hyper growth in the industry. And tech, if anything, has been on a hiring spree. So perhaps what this really comes down to is that with rising interest rates, we're trying to counteract inflation, get it under control, and companies that are reliant on outside funding are feeling the pain. When interest rates increase, it's simply more expensive to borrow money, and at the same time, consumer spending is going down and stocks are crashing. So bringing this back, let's look at the HR legal angles to mass layoffs of this kind. I'm going to jump into my 5 points that I think should be front of mind if you support on the ER or legal aspects of this kind of an exercise in Europe. And it's really important to note that culture, expectations, procedures, and all the legal rights and obligations are different both in and within Europe. So there really does need to be a mindset shift when approaching this in the rest of the world, so to speak, versus in the US itself. So point number 1 is thinking ahead of time about the key risk areas. You don't know what you don't know. So to advise businesses on the showstoppers, you have to really be quite informed. Suffice to say that in Europe, you can create risk right from the planning stages. So you need to be mindful of it early on in the assessment. Agreeing commercially to take some risk is fine, but you really need to know what those risks are in order to get to your endpoint. I'm going to start with some red lines. Criminal sanctions are one area that no business will go near. Take the UK as an example. If you're proposing to dismiss more than 20 employees within a 90-day period, you have to inform the Secretary of State, essentially a government notification. The sanctions for failing to do that or doing it in a manner that's not timely or compliant are criminal, and directors can be personally liable. In other countries, the same might apply if you fail to consult with a particular representative body. European works councils in particular make people shudder. So identifying these red areas up front is really key. Another red line will be where courts or tribunals have the power to declare your terminations null and void. So this is something that can undermine your entire proposal and be really costly. So again, knowing what powers there are and how to proceed in a way that's compliant, but also lets you achieve what you want to achieve is important. Finally, just a note on this point on protected groups. There are categories of employees in certain countries in Europe that are protected from dismissal. You simply can't do it. Perhaps employees on sick leave, union representatives, pregnant employees, those on maternity leave. Those are a few examples. Again, this is an area you should consider ahead of time and feed into the business really as the proposals are being developed. So coming on to point 2, this is about testing the business rationale. So it often starts with a global announcement by the CEO, but that's really focused on positioning external and internal comms about the layoffs. And it's just the beginning. The depth of the rationale that you need to share with employees to justify the redundancies varies greatly across Europe. In some countries, this will involve market comparisons, analysis of financial data, a consideration of the overall size of the business against the headcount reduction. So you have to work on this early on to prevent later legal challenges from employees about the reasons. It might even get you to the point where you need to reassess the proposal altogether, because are you really meeting the required threshold? And then there's the granularity of it. And that's something that's often quite overlooked, where you have individual information and consultation obligations, as well as the collective piece. You might also need to share things like the functional rationale or a role specific rationale. So really the employee knows why their role is at risk. Beyond that, a clearly documented rationale that deals with functions, specific roles, it helps you to prevent legal risk, and in particular around those protected groups. We talked about employees that might be ring-fenced under law, but if they're not, they may still possess a protected characteristic that would allow them to allege that they've been selected perhaps because of a disability or because they're pregnant. So a paper trail of the real rationale that relies on objective business reasons is really helpful to mitigate this risk and to really defend any of these claims if they're brought. Point 3 then is how you select employees for redundancies. And this can really be one of the most significant areas of legal risk in a mass layoff exercise. And if I can emphasize anything, it warrants really early attention. Usually the key driver for an exercise like this is a push for efficiencies, high productivity, high performance. So being able to choose who you dismiss is really quite important to the business, which you'll find out early on. Cases where entire teams or functions are no longer needed tend to be more clear-cut. But if you're selecting employees one over another, a team of 10 reducing to a team of 5, there's always scope for more legal risk, not only because of the risk of bias or discrimination in that selection, but also because many countries in Europe have statutory selection criteria that must be applied. It links back to point 1. Sometimes a failure to do that can lead to a nullified termination altogether. The tendency or desire, at least in my experience, is that from a pure business perspective, you always want to select those who are underperforming, have been regularly absent, perhaps they've been engaged in misconduct in the past, they're not contributing as you would like. And I can understand that. But in some countries, where there's a genuine redundancy situation, you will have the flexibility to do that within your statutory framework. So take the UK as an example. You can include an assessment of performance, achievement against targets, disciplinary records. But in other countries, the statutory selection is very prescriptive. So Germany operates a statutory selection criteria, which includes, amongst other factors, the number of dependents an employee has. In the Netherlands, age is a relevant factor. And in some countries, the last in, first out principle is applied, so length of service becomes much more decisive. I think the key lesson on this point is to think early on before that list, so to speak, has been finalised, because it's difficult and essentially non-compliant to be in a position to reverse engineer the selection if that selection is mandated by law. And perhaps most importantly, if there are information and consultation rights, a selection process that has already taken place can't really be discussed with employees or their representatives and could undermine that process for you when you're otherwise in a position that is very compliant. That brings me nicely onto point 4, which is about redeployment. As a general principle, and perhaps a pretty obvious one, where roles are being replaced like for like, almost backfilling, this won't be a genuine redundancy situation, and it's likely to be challenged depending on your timeframes in terms of hiring. Often, if a business is focused on cost-saving measures, they don't step back and look at the business more holistically. What else is going on in the areas that aren't in decline, for example? In most of Europe, there is some sort of obligation to consider at-risk employees for other open positions and sometimes just redeploy them to those positions. While you'll generally be able to do an assessment of skills, experience, location, the extent to which a business can rely on this to actually deny an at-risk employee an open position is really going to vary. And again, in some countries, that statutory selection will kick in, and you may not be able to run an open recruitment process as you would like without generating quite a substantial legal risk. In the post-pandemic world, this gets really tricky to assess because you've got global teams, remote roles, employees that can work from anywhere. These roles popped up a lot after the flexibility that was brought by remote working in COVID. And for both redeployment opportunities and selection itself, this really needs quite careful analysis. Let me take this conundrum. If I can select based on performance in the UK, but I'm bound to select based on social criteria in another country or based on the last in, first out principle, but that team is cross-border and global, what do I do? It's not really a tried and tested area, so you really have to develop case-by-case solutions on this. And finally, to wrap up, point 5 is mitigation, or what we often call the severance package. There's a tendency to want to treat departing employees well in an effort to protect your corporate brand. We've seen that in the US, companies often take some pride in publicizing the severance packages they're going to offer. In Europe, this needs to be considered carefully as against the existing protections employees have. Can you really adopt a uniform approach? Most countries will have statutory severance entitlements of some kind, so those have to be met as a minimum. And beyond that, there will be discrepancies in terms of paying in lieu of notice. Is that allowed? How are employees compensated for this? There will also be payment for minimum consultation periods that gets factored into the overall financial cost of an exercise like this. Then there's variable or discretionary compensation. What happens to that? What do the documents say? Sometimes the most valuable aspects of your severance package will actually be non-monetary. Outplacement, for example, often gets really good PR as being a way of trying to secure the future of employees that are leaving. And then sometimes the level of the package is really going to depend on the risks you've taken in the exercise itself. Has it been compliant? What's the strength of your rationale? What's the risk that employees are going to bring claims? How have they taken the news? Did they know it was coming? All of this informs the process and really determines what employees' expectations will be in this regard. So there we have my 5 points with what I hope are practical takeaways here. It's tricky to navigate, especially at speed. You can find our restructuring guide on our website. It's cross-border. It walks through a lot of these considerations, and I would say it's a great starting point when you're trying to get a bird's eye view across Europe. Thanks so much, Patty, for having me on.
Thank you so much indeed, Furat. What a great summary of a really complicated area. And thank you for highlighting the tremendous resource we've got to support restructuring and reorganisations. I think what I'm taking away from this is that often businesses think forward planning and good documentation is a nice to have, but when you're dealing with criminal sanctions and potentially voidable terminations, which will undermine the whole process, it's more than a nice to have. And to everyone who joined us, thank you so much. Thank you for listening to today's podcast. We hope you join us again and look out for more content coming soon.